So very good evening, all the participants. The first challenge before students comes to read from where. So for the purpose of students, we have compiled this PPT, which contains the code and the relevant rules and regulations. So you can download it on your laptop. You can take a printout also. Even if you download it from IBBI websites, you will get at different places. You may not be able to get a copy of the book because the cutoff date for our syllabus is 31st March 2023. So that is also important. And I hope most of you would be wishing to appear before 5th of May. From 5th of May, new syllabus is coming. So from 5th of May onwards, the exam will be conducted in new syllabus. Although there are not much changes, but still it is better if you clear the exam before 5th of May. And normally they will not allot you slots in the beginning of May, or even say in the end of April. So better you plan your examination, say maximum by 20th of April. Even if you are new to the subject, I think there is still more than 1 month. And if you devote sufficient time, so you can clear the examination. But please be clear in your mind that simply by attending these classes, you may not be able to clear the exam unless you read the things on your own. So reading on your own is important. And the first step towards that is to download this PPT. You can go through this PPT, or if you are in the habit of reading from the book, then better take a copy of the book, say Taxman or Commercial, which has got amendments which are covered up to 31st March 2023. But that may not be possible as of now, because whenever you go to the bookseller, so he will give you a copy of the 25 edition or 2024 edition. So then you have to ignore the amendments which took place after 31st March 2023. So better you download it from here. If you are in the habit of reading from the laptop, you can directly read from here. So first, let us discuss, even before we start with this PPT. So please tell me what are the various processes. So let me open a word sheet for you. So just Mr. Saif, can you tell me what are the various processes which are there in case of IBC? What are the various processes? Or what is the purpose behind this IBC? Is there any purpose?
Yes, sir. To speedy liquidate the process and through a resolution procedure.
Right. So
ARP
actually,
main purpose of IBC is to the arrangement of the compromise and arrangement of the company, and keep it as a going concern. If it is not possible, then in liquidation.
right. So the basic thing is that first of all, they will try for a speedy resolution. And please remember that all these things, they are for the benefit of the corporate persons or non-corporate persons which are undergoing some financial stress. And if that is not possible, then they allow a speedy exit also. So these are the two things. So let us read from the preamble. So what preamble says about this? I hope my screen is visible. Is it visible?
Yeah.
So it
That's
says an act to consolidate and amend the laws. Earlier also there were laws, like RDB was there, SICA was there, so many other laws were there. Winding up was being taken up by high courts. For individuals and non-corporate persons, they were DRTs and Surface Act. But this is intended to be a comprehensive law, consolidating all the laws. So it is an act to consolidate and amend the laws relating to reorganization and insolvency resolution. So first thing is reorganization. Reorganization means actually, say, putting a new driver in the seat. Reorganization of the business by roping in a new entrepreneur who is ready to bring a solution to the financial problems which this company is facing. And insolvency resolution. Because this company is facing insolvency, there are some liquidity crunches. So this insolvency is also intended to be resolved. Insolvency resolution of corporate persons, partnership firms, and individuals. So whether it is a corporate person, whether it is a partnership firm, whether it is an individual, all are expected to be benefited by this. And please remember that it is a beneficial legislation for the persons who are facing insolvency issues in a time-bound manner for maximization of value of the assets of such persons. Another important aspect is maximization of value of the assets of such persons. So there will be no rushing towards liquidation. First of all, we will try to resolve the insolvency which the corporate person, partnership firm, or individual is facing, and then that also will promote the entrepreneurship because the new entrepreneur will enter. Availability of credit will be there and balance the interest of all the stakeholders because there are various stakeholders in the company. Some of them may be financial creditors, other could be operational creditors. So this IBC, it aims to balance the interests of all the stakeholders, including alteration in the order of priority of payment of government dues. In other laws like income tax, sales tax, customs, priority is towards payment of government dues. But here, the government has taken a back seat in this insolvency and bankruptcy code, and they say, let others be benefited, let others be paid first, like workers, employees, secured creditors, etc., before government dues are cleared. And to establish an insolvency and bankruptcy board of India, because there has to be a regulator for every process. So here the Insolvency and Bankruptcy Board of India is the regulator and for matters connected therewith or incidental thereto. Be it enacted by Parliament in the 67th year of Republic of India as follows. So this act may be called the Insolvency and Bankruptcy Code and it extends to the whole of India. And various provisions shall come into force on different dates as may be notified. Even as of now, all the provisions have not yet been notified. There are various processes, but for every process, the rules and regulations are not there. Like for fresh start process, rules and regulations are still not notified. Similarly, for individual insolvency also, rules and regulations are still not there, but we have to read the sections. Now, before we undertake this study section wise, so let us see the various processes involved. So what are the various processes? So let me share a Word file with you. Yes. So this is the Word file. Various processes involved in IBC and how they are different from each other. Let us have a look at the various processes. The first, because these processes, they may be related to corporate persons, or non-corporate persons. There are only two types. Now let us see what are the various processes for corporate persons. Actually, corporate persons are primarily of two types. It could be a company which could be established under Companies Act 2013 or any other earlier Companies Act. It could be an LLP. It could be a body corporate established under any other law. But here, there is a major departure because it says the financial service providers, they are not covered under the definition of corporate person. So there is a separate process for those financial service providers. So corporate persons, companies, it will cover companies. It will cover LLPs. It could cover any other body corp. But it will not cover financial service provider. Then for non-corporate could be individuals, partnership firms or sole proprietorship firms. Partnership firms and sole proprietorship. Now, what are the processes for corporate persons? Okay. Processes for corporate persons. First is corporate insolvency resolution process. Corporate insolvency resolution process. So this is the first process whereby the corporate person, the company or LLP or any other body corporate which is facing insolvency related issues. So there will be a process called this CIRP process, corporate insolvency resolution process, whereby an insolvency professional shall be appointed and it will try for a resolution of this corporate. In corporate insolvency resolution process also, there is a fast track corporate insolvency resolution process. Fast track CIRP is also there, which is restricted for certain types of companies like startups. If you are a small company, startups, and companies with asset size not exceeding 1 crore. So fast track CIRP is also there. Then there is a pre-pack process also. That is also for corporate persons. Now, what is this pre-pack? Pre-pack is restricted to corporate MSMEs. Corporate MSMEs. Whereby companies which are having a particular turnover or investment, so they can offer a scheme on their own as to how they want to repay the debt by means of a resolution plan. There is a concept in CIRP for voluntary liquidation also. So liquidation is there. So all these processes, either it will be through CIRP or fast track or pre-pack, depending upon the type of company and depending upon the conditions which are being met. If that is not possible, then liquidation. Then there is a process of voluntary liquidation also, that you can voluntarily liquidate your corporate person even if you are not facing this insolvency issues. But that is there only for solvent companies. Similarly, so these are the various processes for corporate person. Any other process apart from this for corporate persons? CIRP, fast track, pre-pack, liquidation, voluntary liquidation. Any other process, Sudhakar ji, for corporate persons?
No, sir.
Okay.
The other one, sir.
So now for non-corporate. So for non-corporate persons, what are the various processes? First is the fresh start process. What is this fresh start? Fresh start means if you are a person with limited means, you are not having much income or much assets or much liabilities, then you can start afresh. You can start on a clean slate. You need not pay anything. So there is a process. Then individual insolvency. And then bankruptcy. So these are the processes in case of non-corporate persons. Fresh start is restricted for certain types of individuals which are having very low assets, income or liabilities. Then this individual insolvency, whereby the individual or the partnership firm which is facing insolvency issues is required to submit a repayment plan as to how it proposes to repay the debts. And in case that is not possible, then bankruptcy is there. So these are the various processes.
सर पीजी टू सीडी कहाँ आएगा सर?
PG to CD, actually, very good question. PG to CD, let us see another angle to this. PG to CD. Now, this personal guarantor to CD, the word personal itself denotes that it is a non-corporate person.
Hmm.
There are two types of guarantors. So rather PG to CD, instead of saying PG to CD, we can say guarantor to CD.
हाँ.
Let us say guarantor to CD. Now this guarantor to CD may be a corporate person or it could be a non-corporate person. That means the person who has given the guarantee, it could be a company or it could be an individual or a partnership firm or it could be a non-corporate person. So in case it is a corporate person, then same process. CIRP, liquidation, etc. In case of non-corporate persons, then insolvency or bankruptcy. So these will be covered under the above processes, depending upon their constitution. If a company has given a guarantee, then CIRP shall be started against that company. It could be fast track also in case it meets certain conditions like being a small company or a startup or having a particular asset size. For pre-pack corporate MSMEs, if they have incurred their default, so then they can also go in for this pre-pack. And then liquidation, voluntary liquidation, etc. So this is the process. Regarding personal guarantors to corporate debtors, only for personal guarantors to corporate debtors, which could be either individuals or partnership firms, rules and regulations are there. So rules and regulations are not yet notified for individuals. Suppose you are an individual. Mr. Sudhakar is an individual. Now, there could be two things. Number one, suppose Mr. X has taken a loan. Okay? He is an individual. Then the process of his insolvency will be taken up by the creditor with the DRT. But if Mr. X is an individual who has given guarantee to a company, then there are rules and regulations and that will be covered. That will be the adjudicating authority for the same shall be NCLT. Now let us do it section wise. Just a minute. Various processes. So before we start, Sudhakar ji, you would like to add anything to this basics?
नहीं सर, इसको perfect sir.
Okay. So now, Bear Code and regulations. So we were here. Okay. So section 1 says this code may be called the Insolvency and Bankruptcy Code 2016 and it extends to the whole of India. Section 2 regarding applicability. The provisions of this code shall apply to any company incorporated under the Companies Act or under any previous company law, any other company governed by any special act for the time being in force. So there are various companies which are governed by any special act. So there are like Food Corporation of India is there, LIC is there. So there are various companies which are governed by any special act. So in their cases, there could be insolvency related provisions in those acts also. So to that extent, they will be governed by their respective acts. Suppose LIC is formed under LIC of India Act. Now suppose in LIC of India Act, there is this provision regarding insolvency. So those provisions will be overriding IBC. So it says any other company governed by any special act for the timing in force, except insofar as the said provisions are inconsistent with the provisions of such special act. Any LLP incorporated under the Limited Liability Partnership Act, such other body incorporated under any law for the timing in force, as the central government may by notification specify in this behalf. Now, but for this, a notification has to be given. Such other body incorporated under any law for the timing in force. It could include a foreign company also. As the central government may by notification specify in this behalf. It says such other body incorporated under any law for the timing. It could be under Indian law, it could be under foreign law also. But for this, a notification has to be issued by the central government. Then personal guarantors to corporate debtors, partnership firms and proprietorship firms, and individuals other than persons referred to in clause E. So why they have divided these individuals in two parts? So they have covered personal guarantors to corporate debtors separately and individuals other than personal guarantors to corporate debtors separately, because for individuals there is a separate procedure and for personal guarantors there is a separate procedure. Because only rules and regulations have been notified for personal guarantors to corporate debtors, that is, they have carved out a separate exception for this in relation to their insolvency, liquidation, voluntary liquidation, or bankruptcy, as the case may be. Now, Section 3. Section 3 says, in this code, unless the context otherwise requires, board means the Insolvency and Bankruptcy Board of India. Bench means a bench of the adjudicating authority. So there is a concept of adjudicating authority. So instead of court, they have given this concept of adjudicating authorities here. And adjudicating authority for corporate persons is NCLT. And adjudicating authority for individuals and partnership firms is DRT. Bylaws means the bylaws made by the Insolvency Professional Agency. So there is a concept of Insolvency Professional Agency also under IBC. And there are 3 insolvency professional agencies which are promulgated by the 3 respective institutes. Charge means an interest or lien created on the property or assets of any person or any of its undertakings or both, as the case may be, as security and includes a mortgage. So charge. Whenever you take a loan, you create a charge on the property. So you create an interest actually or lien for the benefit of the person from whom you have taken the loan. So he develops an interest in that property. So charge means an interest or lien created on the property or assets of any person or any of its undertakings or both, as the case may be, as security and includes a mortgage. Chairperson means the chairperson of the board. Board here means IBPI. Claim. There are very few definitions which are relevant here for the purpose of initial understanding, and as we delve into the various intricacies of IBC, then we'll go in detail to those definitions. But the definition of claim, the definition of debt and default, these are the 3 most important definitions. Now claim. Claim means a right to payment. So whenever you have got a right to payment from any person, then that means you are having a claim. Right to payment, whether or not such right is reduced to judgment, fixed, disputed, undisputed, legal, equitable, secured or unsecured. Then right to remedy for breach of contract. Suppose the other party, there was a contract between 2 parties and one of the parties has breached the contract. And there is a remedy for that breach. And you have got the right. as a party. There are two parties, A and B. B has breached his part of the contract. Now A has the right to remedy. But this right will be covered under claim only if such breach gives rise to right to payment. Okay? Whether or not such right is reduced to judgment, fixed, matured, unmatured, disputed, undisputed, secured, or unsecured. There is a civil contract which is being executed between two parties. There is a contractor and there is the client. So as a client, you have got certain obligations. As a contractor, he has got certain obligations. So both have to perform their part of the promise. As a client, you may be required to give him free supply of steel and cement. As a contractor, he will be liable for execution of the contract. So if any of the parties breaches his part of the promises and there is a right to remedy, say in the form of liquidated damages. So for those liquidated damages, they will be covered under claim. Corporate person means a company, LLP, or any other person incorporated with limited liability under any law for the timing in force. So whether foreign companies are covered, the answer is yes. Any other company incorporated with limited liability under any law for the timing in force, but shall not include any financial service provider. So they have excluded financial service provider from the definition of corporate person. Why it is so? The answer we will find in section 227, which says that in case of a financial service provider, which are basically banks or financial institutions, so action against them can be taken only in consultation with their regulator, which is normally RBI. So central government will get in touch with the regulator of this financial service provider, and then they will issue a notification that how this process is to be taken. But for normal corporate persons, the process is different. For this financial service provider, the process is slightly different. So that is why they have excluded financial service provider from the definition of corporate person. Corporate debtor. Corporate debtor means a corporate person who owes a debt to any person. So there could be a debtor, there could be a corporate debtor. If an individual or a partnership firm has to give some money, so then they will be covered under debtor. But if the company has to give the money, then it will be covered under corporate debtor. Corporate debtor means a corporate person who owes a debt to any person. Creditor means someone who has to receive the money. Core services means the services rendered by an information utility. So there is a concept of information utility in IBC which says that the information shall be stored. So this is basically a storehouse of information. And various banks, financial institutions, other creditors, financial creditors, operational creditors, they are feeding information to this information utility. And it is responsible for accepting, for safe and accurate recording, for authenticating and verifying the financial information and providing access to information. Creditor means any person to whom a debt is owed and includes a financial creditor, an operational creditor, secured creditor, unsecured creditor, and a decree holder. It's very important to remember that here they have used the word creditor. They have not used the word corporate creditor. Why? Because creditor can take action under part 2, under part 3. But the against whom action is to be taken, so there is a separate part for that. If you want to take an action against a corporate person, then you are covered under part 2. If you want to take action against an individual or a partnership firm, then you have to go to part 3. But the creditor, even if he is an individual or a partnership firm, he can take action against a corporate person under part 2. So the action against whom you are taking action, so for that purpose you have to go to the respective parts. Why? Because it is a beneficial legislation for the persons who are facing insolvency issues. So please remember, it is not a debt recovery mechanism. It is a mechanism to facilitate insolvency resolution. And if that is not possible, then speedy exit in the form of liquidation or bankruptcy of the person who is facing this insolvency issues. So creditor means any person to whom a debt is owed and includes a financial creditor, an operational creditor, secured creditor and unsecured creditor and a decree holder. Another important definition is of debt. Debt means a liability or obligation in respect of a claim which is due from any person and includes a financial debt and operational debt. Although we'll read about it in detail, but financial debt means basically the loan given by a person to another. And operational debt means rendering of services, which could be either supply of goods or supply of services. And even employees are covered under operational debt. Even government dues, income tax, sales tax, customs, they are all covered under operational debt. Default means non-payment of debt when whole or any part or installment of the amount of debt has become due and payable and is not paid by the debtor or the corporate debtor as the case may be. So another important definition is of default. Default means non-payment of debt. But please remember that they have given separate definitions for claim and debt. So claim means right to payment or right to remedy for breach of contract, which gives rise to right to payment. But now debt means a liability or obligation in respect of a claim which is due. So there could be a scenario where an amount is due and there could be a scenario when the amount is not presently due. So if the amount is due, then it is covered under debt. If the amount is not due, although there is a right to payment, so that will be covered under claim. And default will be only on those cases when there is a non-payment of debt. When whole or any part or installment of the amount of debt has become due and payable. Let us understand it by way of an example. There is an employee and that employee has rendered services to the company. So he has a right to claim. But if that amount is due, so only then it will be covered under debt. If that amount is not yet due, then it will be covered under claim only. And if there is a non-payment of debt, then it will be covered under default. So we can skip the other definitions. So we can again come back to these definitions later. So section 4. Now let us directly jump to section 4. So what section 4 says? Section 4 says that this part, so part 1 was there, part 1 was applicable to the whole of the code. So if we read part 1, what it says? Part 1 says preliminary. Part 1 is preliminary and it applies to the whole of the code. So part 2 is applicable for only corporate persons, insolvency resolution and liquidation for corporate persons. Similarly, part 3 is there. Part 3 is for insolvency resolution and bankruptcy for non-corporate persons. Part 4 and part 5. Part 4 deals with various procedural issues like IPA, IP, IBBI, information utility, etc. And part 5 deals with miscellaneous provisions. So part 2, application of this part. So it says, this part shall apply to matters relating to insolvency and liquidation of corporate debtors, where the minimum amount of default is 1 lakh rupees. So when this IBC started, the amount initially was 1 lakh rupees. Provided that the central government may by notification specify the minimum amount of default of higher value, which shall not be more than 1 crore. But in the act, they kept a provision that the central government may by notification specify the minimum amount of default of higher value, which shall not be more than 1 crore rupees. So they have issued a notification and now the minimum amount of default is 1 crore rupees. Provided further that the central government may by notification specify such minimum amount of default of higher value, which shall not be more than 1 crore rupees for matter relating to prepack. So prepack, as I told you, is restricted for certain corporate MSMEs only. And for these, it says the maximum amount is the minimum amount of default cannot be more than 1 crore rupees. So minimum amount of default for corporate person, corporate MSMEs which are covered under PPAC, they have specified as 10 lakh rupees. So they have issued a notification for this. But please note, only minimum amount has been specified, whether it is for corporate persons or for non-corporate persons. So if there is a default of say 100 crores, the company has got two options. It can go in for the creditor can go, or the company can go in for, this corporate person can go in for CIRP under section 10 or under pre-PAC in section 54 A to P. Now, definition. Part 5. Part 5 also contains some definitions like part 1. Some definitions are given in section 3, which apply to the whole of the code, and some definitions are given in section 5, which apply to part 2 only. So we'll read these definitions whenever opportunity arises. Now section 6. Section 6 is persons who may initiate this CIRP. So it says where any corporate debtor commits a default. Where any corporate debtor commits a default, the definition of default we have already seen. Default means when a debt is due and it is not paid. So then there is a default. Minimum amount of default 1 crore rupees for corporate persons. For pre-PAC 10 lakh rupees. Minimum. No limit to maximum. So where any corporate debtor commits a default, a financial creditor, an operational creditor, or the corporate debtor itself may initiate insolvency resolution process. Now, financial creditor. Let us see the definition of financial creditor before we move to section 7. Because section 7 says initiation of CIRP by financial creditor. So we must know the definition of financial creditor. So let us see what is the definition of financial creditor. So financial creditor, actually it is given in section 3. So section 3, if we see, section 3 will talk of financial creditor. First of all, let us see the definition of creditor. So creditor means any person to whom a debt is owed and includes a financial creditor, an operational creditor, secured creditor, an unsecured creditor, and a decree holder. So this is the definition of creditor. Now let us see the definition of financial debt. And debt means a liability or obligation in respect of a claim which is due from any person and includes a financial debt and operational debt. Okay. So creditor means a person to whom the debt is owed. Now we have to see the definition of debt. And debt means a liability or obligation in respect of a claim which is due from any person and includes a financial debt and operational debt. Now let us see the definition of financial debt. So financial debt. Financial debt is given in section 5, subsection 8. Basically, although it will have many points, but the first point is the money borrowed against the payment of interest. Easiest to understand. And financial debt means a debt along with interest, if any, which is disbursed against the consideration for the time value of money and includes money borrowed against the payment of interest. They have given in section 5, subsection 8, they have given various examples of what could be the different types of financial debts. You are availing CC facility, it is a financial debt. You have engaged underwriters, so they are having their claim, it is a financial debt. There are some receivables which are sold or discounted other than any receivable sold on non-recourse basis, it is a financial debt. Any amount raised including any forward sale or purchase agreement having the commercial effect of borrowing, financial debt. Home buyers, financial debt. Any derivative transaction, to cover against fluctuation, financial debt. Any counter indemnity given, financial debt. So all these definitions are of financial debt, which are given in section 5, subsection 8. Now, if we see section 7 says that the person who is a financial creditor, he gave the money to the company and that money was not paid back. So, what is the option available to him? He can initiate the CIRP process. So, initiation of corporate insolvency resolution process. It doesn't say recovery. It says corporate insolvency resolution process by financial creditor. So, now what are the various types of financial creditors covered here? It could be an individual, it could be a joint lending, or it could be the case of home buyers or a class of creditors like deposit holders, debenture holders, etc. etc. So there are different procedures if you are an individual financial creditor or you have given as a class of creditors. Like suppose home buyers have given money. So then there is a stipulation that certain minimum number has to be there for initiating this process. So initiation of CIRP process by financial creditor. So it says a financial creditor either by itself or jointly with other financial creditors or any other person on behalf of the financial creditor as may be notified by the central government may file an application for initiating CIRP against a corporate debtor before the adjudicating authority when a default has occurred. Okay? So it could be either singly or jointly. Provided that for financial creditors referred to in clauses A and B of subsection 6A of section 21. So now it is referring to section 21. And section 21, if we see, it talks of joint lending by bankers. It talks of deposit holders, debenture holders, home buyers, class of creditors, etc. etc. So there is a minimum stipulation that so many creditors must join. Suppose a banker has given a loan to a company. So banker can initiate this CIRP process against that company on its own. If there is a consortium of banks, then either any one of them or all of them, they can join hands together also. So they can start this process. But if it is a case of those which are covered under section 21, 21(6)(a), A and B, so then it has to be a joint application. An application for initiating CIRP against the corporate debtor shall be filed jointly by not less than 100 of such creditors in the same class or not less than 10% of the total number of such creditors in the same class, whichever is higher. So as I told you, class of creditors is, say, in case of deposit holders or debenture holders or home buyers. So in that case, it has to be at least 100 or not less than 10% of the total number of such creditors in the same class, whichever is less. Provided further that for financial creditors who are allottees under a real estate project. So here it has to be project wise. Under the same real estate project, you have to take at least 100 or not less than 10% of the total number of such allottees under the same real estate project, whichever is less. Provided also that where an application for initiating CIRP against a corporate debtor has been filed by a financial creditor referred to in the first and second proviso. So because this provision came at a later date, so they say if an application has been filed earlier, so then it has to be accordingly amended. Okay. This is the notification which was issued raising the minimum amount of to 1 crore rupees. And this explanation says that for the purpose of this subsection, a default includes a default in respect of a financial debt owed not only to the applicant financial creditor, but to any other financial creditor of the corporate debtor. The financial creditor shall make an application under subsection 1 in such form and manner and accompanied with such fees as may be prescribed. So then you have to go to the respective rules that how you can file the application. We'll read about it in detail. Then they have to attach certain documents along with the application. Then adjudicating authority also. Now what is the time limit within which this application can be filed? Suppose a banker gave a loan to company XYZ Limited. So within how much period the banker can file the application against this company? And when this period will start? There are two questions. The first question is, the situation is that the banker has given a loan of say 2 crore rupees to XYZ Limited. Now, what is the time period within which this banker can file the application, and when it will start and when it will end? Anyone?
From the day notice has been issued.
Actually, we have already seen section 4. So the trigger point is the default. So we have to see when the cause of action has arisen. So the cause of action arises when there is a default. So first of all, we have to see that whether is a default. Minimum amount as of today is 1 crore rupees for normal CIR. So if there is a default of 1 crore rupees or more. So from that date, from the date of the default, the cause of action has arisen. And Limitation Act also applies to IBC. So we have to see according to the Limitation Act. So normal processes period is 3 years. 3 years is the normal limitation period unless the delay is condoned. If delay is condoned, then application could be entertained at a later date also. But normally 3 years from the date from the cause of action. Okay. The financial creditor shall along with the application furnish record of the default recorded with the information utility or such other record or evidence of default, name of the resolution professional. Another important thing here is that when you file the application as a financial creditor or as a corporate debtor, you have to give the name of the resolution professional you propose to appoint as IRP. You have to take his consent in Form 2 and you have to give the name of the resolution professional proposed to act as an IRP. Now, till the time this IRP is appointed, this resolution professional is appointed. So till that time, it is a private arrangement between the applicant and the insolvency professional. Because suppose you are a normal creditor. So first question, you are not a bank, you are an individual who has given loan to a company. Whether you can file application against the company or only bankers are allowed or only home buyers are allowed. You are an individual. Whether you can file an application under section 7. The answer is yes.
Yes, also can find.
Yes. So anybody can. Corporate, non-corporate, individual, partnership firm. But against whom this application has to be filed? In part 2, against corporate. Because in part 2, we are studying corporate insolvency resolution process. So section 7, if we again read what it says initiation of CIRP by financial creditor. Okay. And section 6, if we see, it says where any corporate debtor commits a default. So who is committing the default? Any corporate debtor in part 2. A financial creditor. Now financial creditor is one who has given financial assistance to the company. An operational creditor who has given goods or services. Or the corporate debtor itself may initiate CIRP in respect of such corporate debtor in the manner provided under this chapter. Now the adjudicating authority also has got certain time limits. So within 14 days, they will decide on the application. So they will either admit the application or they may reject the application in case there are certain defects in the application. So it will allow a time period of 7 days to rectify such defect. And then they will admit. And once this application is admitted, so then the process will start. Section 8. Section 8 talks of insolvency resolution by operational creditor. Like in section 7, we have seen that financial creditor, and they have given different types of financial creditors, okay, which can initiate this process. So section 8 and section 9 both are for operational creditors. Section 9 talks of application for initiation, and section 8 talks of insolvency resolution by operational creditor. So first of all, you will try to resolve the insolvency of the corporate debtor. It says an operational creditor may, on the occurrence of a default, deliver a demand notice of unpaid operational debt or copy of an invoice demanding payment of the amount involved. So if you are an operational creditor, you cannot straight away file an application for insolvency resolution. So what you have to do? You have to deliver a demand notice of unpaid operational debt or copy of invoice. If you are a financial creditor, then also whether you are required to deliver this demand notice, the answer is no. So for filing an application under section 7, there are only two conditions. One, there is a default. Second, application is complete. If we again go back to section 7, then it says the answer is given in section 7, subsection 5. What it says, where the adjudicating authority is satisfied that default has occurred and application is complete and there is no disciplinary proceeding pending against the proposed resolution personnel, it may by order admit such application. So there is no mention of dispute or demand notice, copy of invoice, etc. etc. So they will see only three things. Number one, default has occurred. Second, application is complete. And third, no disciplinary proceedings are pending. Suppose default has not occurred, they will reject the application. Suppose the application is not complete, they will give time of 7 days to rectify the defect. And if there is any disciplinary proceeding, then in that case, they will refer the matter to the board, who will give the name of another insolvency professional who shall be appointed. Okay. Now section 8. Section 8 talks of certain procedures to be followed before an application is filed. So first of all, you have to deliver a demand notice of an unpaid operational debt or copy of an invoice demanding payment of the amount involved in the default. The corporate debtor shall be the period of 10 days. So corporate debtor has got a time period of 10 days of the receipt of the demand notice or copy of the invoice, and he will say existence of a dispute, if any, or record of pendency of the suit or arbitration proceeding filed before the receipt of such notice or invoice in relation to such dispute. So definition of dispute here is important. What is the meaning of dispute? And definition of dispute, for this we have to refer to section 5, subsection 6, I think. So section 5, subsection 6, we see it says dispute. This is an inclusive definition. Dispute includes a suit or arbitration proceeding. So there could be a suit, there could be arbitration proceeding, but since it is an inclusive definition, there could be a case of a dispute even though there is no suit has been filed, even though no arbitration proceedings are going on, still there could be a dispute. And it could be relating to the existence of the amount of debt. One party is saying that I have given the money, the other party is saying I have not received any goods or services. Because here we are talking about dispute only in terms of operational debt. Section 7. Quality of goods or service or the breach of a representation or warranty. So now let us again go back to section 8. So whenever any question arises regarding a particular term, we'll go again to that definition part, which are mainly contained in section 3 or section 5. So first of all, you will deliver a demand notice or copy of an unpaid operational debt, copy of an invoice. 10 days are given to the corporate debtor within a period of 10 days of the receipt of demand notice or copy of invoice. So he can say three things. One, there is a dispute. As I have already told you, it is not a recovery mechanism. It is an insolvency resolution. So if there is a dispute, you go to some other forum. You go to court, you go to commercial court, you go to DRT, wherever you want to go, you go. But here, that option is not there if there is a dispute. In case of financial debt, the question of dispute is not relevant. But in case of operational debt, which may be given by a supplier of goods or a provider of services or the government, so this dispute question will have to be answered first. So if there is a dispute or a record of pendency of the suit or arbitration proceeding. So in case of a suit or arbitration proceeding which is filed before the receipt of such notice or invoice in relation to such dispute, so it shall be presumed that there is a dispute. So either there has to be dispute or some suit or arbitration proceeding is pending. But suppose you receive a notice today and you raise the dispute tomorrow, then that is not allowed. It has to be before the receipt of such notice or invoice in relation to such dispute. The payment of unpaid operational debt. Or second thing you can say is that I have already paid this amount. So how I will prove? By sending an attested copy of the record of electronic transfer of the unpaid amount from the bank account of the corporate debtor, or by sending an attested copy of a record that the operational creditor has encashed a check issued by the corporate debtor. Okay? For the purpose of this section, a demand notice means a notice served by an operational creditor to the corporate debtor demanding payment of the operational debt in respect of which the default has. Okay? Now, if nothing is said, you have given a demand notice demanding payment. The corporate debtor does not revert. So then what is the option? Whether you have to send second notice, the answer is no. So you will give them 10 days. Okay? You will deliver him the demand notice. You will give him a period of 10 days. In 10 days period, he has to act. So he will act in either of the following ways. Number one, he will point out that there is a dispute or there is a suit or arbitration proceeding. Second is, he may say that I have already paid. Okay? These are the two things he will say. Now, if he doesn't say that there is a dispute or he doesn't say anything about the payment, then you can file this application. But while filing this application also, you have to submit an affidavit that the dispute has not been raised by the corporate debtor. So section 9. After the expiry of the period of 10 days from the date of delivery of the notice or invoice demanding payment under subsection 1 of section 8. But the point is, they have said date of delivery. So delivery is important here. Another important thing is service of notice. Explanation. For the purpose of this section, a demand notice means a notice served by an operational creditor. So there must be a delivery, there must be a service of notice. So that is also important. Or invoice demanding payment under subsection 1 of section 8, if the operational creditor does not receive payment from the corporate debtor or notice of the dispute. So he could say either of the two things. He may say that there is a dispute. So then in that case, he is not required to make the payment. And still, the operational creditor cannot file an application under section 9 because it is not a recovery mechanism. Okay? But he neither points out any dispute nor makes the payment, then the operational creditor can file this application. Okay? The application shall be filed in such form and accompanied. So rules are there. We'll read about them in detail. Along with the application, you have to give the copy of the invoice demanding payment or demand notice delivered by the operational creditor. So you have to prove delivery also. Affidavit that there is no notice given by the corporate debtor relating to dispute. So you have to prove it by way of an affidavit also that no, the dispute has not been pointed out by the corporate debtor. There is no dispute. A copy of the certificate from financial institution maintaining accounts of the operational creditor confirming that there is no payment of an unpaid operational debt by the corporate debtor if available. So if this is available, fine. Otherwise, no need. A copy of any record with information utility. Information utility, I already told you, is a repository of financial information. So if that copy is there of any record with information utility confirming that there is no payment of an unpaid operational debt by the corporate debtor if available, any other proof. Then in case of financial creditor, it is essential to propose the name of the resolution personal. Let us go back again to section 7. So if we see section 7, so section 7 says the financial creditor, section 7 subsection 3, it says the financial creditor shall, the word used is shall, along with the application. And 3b says the name of the RP. So it is mandatory. But in case of operational creditor, the word used is may. So what it says, the operational creditor. So section 9, subsection 4, an operational creditor initiating CIRP under this section may. So the word may is highlighted. May propose a resolution proposal. So there could be a case where the operational creditor is filing the application on its own. Okay. In that case, board will, adjudicating authority, in consultation with the board, shall appoint. Okay. So what the adjudicating authority? Same period of 14 days is there with the adjudicating authority. So they shall admit the application and communicate such a decision to the operational creditor and the corporate debtor if the application made under subsection 2 is complete and there is no payment of the unpaid operational debt, the invoice or notice for payment to the operational creditor has been delivered by the operational creditor. No notice of dispute has been received, or there is no record of dispute, and there is no disciplinary proceeding pending against any resolution professional, or they will reject the application and communicate such decision to the operational creditor in case the application is incomplete or there has been payment or the creditor has not delivered the notice or invoice or notice for payment, or notice of dispute has been received by the operational creditor, or there is a record of dispute in the information utility, or a disciplinary proceeding is pending. Okay. If there is any defect, then the adjudicating authority shall give an opportunity to rectify the defect. And the corporate insolvency resolution process shall commence from the date of submission. So this is section 7, 8 and 9. Now section 10. Section 10 talks of initiation of corporate insolvency resolution process by corporate applicant. So there is a default. Neither financial creditor nor operational creditor has filed the application. So the question is that whether the company itself or any person on behalf of that company can file the application. The answer is yes. But the word used is corporate applicant. They have not used the word corporate person or corporate debtor. They have used the word corporate applicant. Okay. Now, what is the meaning of corporate applicant? Before reading section 10, let us see the meaning of corporate applicant. The definition of corporate applicant is given in section 5. Section 5, subsection 5. Corporate applicant means a corporate debtor, or for simple understanding, you can say a member or partner of the corporate debtor. Basically, it will be in the case of LLP. So a member or partner of the corporate debtor who is authorized to make an application for CIRP. Okay. An individual who is in charge of managing the operations, say CEO, CFO, etc. A person who has the control and supervision over the financial affairs, CFO. So these are the persons which are covered under corporate applicant. So either the company or CEO or CFO or manager or partner of the LLP who is authorized to make an application. So these are all covered under corporate applicant. Now let us go to section 10. Section 10 says initiation of corporate insolvency resolution process by corporate applicant. What it says? Where a corporate debtor has committed a default, a corporate applicant thereof may file an application for initiating corporate insolvency resolution process with the adjudicating authority. The application under subsection 1 shall be filed in such form and as may be. So we have to see the rules. What is the form number, etc. Please. And what are the documents to be furnished? The corporate applicant shall, along with the application, furnish the information relating to its books of accounts and such other documents for such period as may be specified. So they have to give the information relating to books of accounts. Information relating to the RP proposed to be appointed. So here also it is mandatory to give the name of the resolution professional who shall be appointed as IRP. And the special resolution passed by the shareholders of the corporate debtor or the resolution passed by at least 3/4 of the total number of partners of the corporate debtor. Because it could be an LLP. In case of LLP, it has to be 3/4 of the total number of partners. Okay. And in case of company, it has to be special resolution. And the adjudicating authority shall within a period of 14 days, it may either admit or reject the application. Okay. If there is any defect, then that defect shall be cured. So we have covered up to section 10. And during COVID period, section 10A was also there, suspension of initiation of CIRP. So what it says, it said, notwithstanding anything contained in section 7, 9 and 10, an application for initiation of CIRP for any default arising on or after 25th March for a period of 6 months or such further period not exceeding such date as may be notified. So because during COVID period, the situations were different. So they said, if any default occurs during COVID period, because businesses have stopped functioning. So if there is any default, then an application cannot be filed. Provided that no application shall ever be filed for initiation of CIRP for the default occurring during the said period. So there are two things. Number one, if the default occurs during this period, okay, then it says no application shall ever be filed. But first thing it says for any default arising on or after 25th March. Explanation: for the removal of doubts, it is hereby clarified that the provisions of this section shall not apply to any default committed under the said sections before 25th March. Because during COVID period also, applications were being filed. Hearings were also taking place electronically. So if the default has occurred before this COVID period, so an application can be filed. Now, let us see some stories. Let us cover some stories before we depart for today's session. So let me tell you a story. Just a minute. Let me share the screen also with you. So in this case, a program used to come on Star TV. So what was the program? The name of the program was Nach Baliye. And for that program, actually, there were two parties. One was Mobilox Innovation, Mobilox Innovations, and then there was Kirusa Software. So Kirusa Soft, Mobilox Innovations, they got the contract for this technical backup for this Nach Valiye program, which was being aired on Star TV. And Mobilox, they entered into a non-disclosure agreement with Kirusa Software, who were to oversee the electronic voting. Like in case of KBC, you have seen the concept of electronic voting. Okay? So similarly here in Nach Valley also, the participants were giving the votes. And that part was being handled by Kirusa Software. But Mobilox Innovations, in their non-disclosure agreement, which is they signed with Kirusa Software, they told them that, okay, you do not disclose this fact to the public that we are doing this program, because Mobilox was the main contractor. But Kirusa Soft, they offloaded certain part to Kirusa Software with a non-disclosure agreement. But what Kirusa Software did? Kirusa Software disclosed this thing before on their website that they are executing this project on behalf of this Star TV Nach Valiye program. So there was a breach of the non-disclosure agreement. And we have already seen the definition of dispute in section 5 subsection 6, which says breach of representation or warranty. So there was a clear-cut case of dispute. So the question here was, although no court case was pending. So we have seen the definition of dispute. So again, let us go back to the definition of dispute, which is covered under section 5 subsection 6. So it says dispute includes. So what is the wording used? They have said dispute includes. So let me read the definition of section 5 subsection 6. It says dispute includes a suit or arbitration proceeding. So the first question is, suppose no suit has been filed, no arbitration proceeding is pending. Still, whether there could be dispute? The answer is yes. And it says relating to existence of the amount of debt, quality of goods or services, or the breach of a representation or warranty. So whether there was a breach of representation or warranty, the answer is yes. In this case, in view of the circumstances which I have told you. So first thing there it says, now there was a mention about section 8 also. Section 8 2A. Section 2A, 8 2A also, let us read this section 8 2A also along with this. Eight 2A says, existence of a dispute, if any, or record of the pendency. So it says word and in section 8 2A to be read as or. Earlier, actually the words used were if any and, but then it was replaced with if any or. Existence of when this case came, so it says the word used at that time when this case came up before Supreme Court, the word used was existence of a dispute, if any, and record of pendency. So Supreme Court said that this word and is to be read as or, and then there was an amendment to the act also. So word and in section 8 2A to be read as or. Now if you see, now if you read section 8 2A, it says or. It says the existence of a dispute, if any, or. So it said the word and occurring in section 82A must be read as or, keeping in mind the legislative intent and the fact that an anomalous situation would arise if it is not read as or. If read as and, disputes would only stop of the bankruptcy process if they are already pending in a suit or arbitration proceeding and not otherwise. This will lead to great hardship in that a dispute may arise a few days before triggering of the insolvency process, in which case, though a dispute may exist, there is no time to approach either an arbitral tribunal or a court. So it says the word and is to be read as or, but now the code itself has been amended. So existence of a dispute falling within inclusive definition. So it says, so we have to read section 5, subsection 6, and then section 8 to A also. 8 to A has been amended. So we have seen that a dispute is said to exist so long as there is a real dispute as to the payment between the parties. That would fall within the inclusive definition contained in section 5, subsection 6. The correspondence between the parties would show that on 30th January 2015, the appellant clearly informed the respondent that they had displayed the appellant's confidential client information and client campaign information on a public platform, which I briefly told you, which constituted a breach of trust and a breach of the non-disclosure agreement between the parties. They were further told that all amounts that were due to them were withheld till the time the matter is resolved. On 10th February, the respondent referred to the non-disclosure agreement of 26th December and denied that there was a breach of the NDA. The court went on to hold that going by the aforesaid test of existence of a dispute, it is clear that without going into the merits of the dispute, the appellant has raised a plausible contention requiring further investigation. So what the Supreme Court in this case said? Supreme Court said that even the adjudicating authority will not go into the merits of the dispute. So they will see where if it is not a patently feeble legal argument or an assertion of facts unsupported by evidence. So what the adjudicating authority has to see, that it is not a just plea to ignore the payment or to avoid the payment. So it has to be ensured that it is not a patently feeble legal argument or an assertion of facts unsupported by evidence. Defense is not spurious, mere bluster, patently frivolous or vexatious. A dispute does truly exist in fact between the parties, which may or may not ultimately succeed. So they say we don't have to go to the merits of the dispute, but we have to ensure that it is not a merely feeble argument or an assertion of facts unsupported by evidence. Okay? And the appellate tribunal was wholly incorrect in characterizing the defense as vague, got up and motivated to evade liability. So Supreme Court dismissed the appeal and set aside the judgment of the appellate tribunal. Okay? So this was the case. Mobilox Innovations, which was a case on section 8 and section 9. So section 5 subsection 6 was discussed here. Section 8 and 9 were also discussed here. Now let us see the case of this Innovative Industries versus ICICI Bank. So what it said? So application here was filed by the financial creditor in this case. So application was filed by ICICI Bank as a financial creditor of Innovative Industries under section 7 on account of default made by the CD in payment of amount due. Okay. So here this Innovative Industries, they raised the plea that okay, we are a SIC unit, we are located in Maharashtra, and in Maharashtra there is a Maharashtra Relief Undertakings Act. So which allows certain moratorium, which allows say temporary suspension of liabilities. Okay. It says under Maharashtra Relief Undertakings Act, all liabilities of the appellant except certain liabilities with which we are not concerned and remedies for enforcement thereof were temporarily suspended for a period of 1 year in the first instance under the first notification and another period of 1 year under the second notification. So here the point is, if there is any state legislation which allows certain deferment of payment and the financial creditor does not pay, then whether IBC can still be availed, whether an application by a financial creditor can still be filed, the answer is yes. Because there the question came of supremacy of the legislation. One is a state legislation. The Maharashtra Relief Undertakings Act, which was referred to in this case by Innovative Industries, it is a state legislation. And if there is any repugnancy between a state legislation and central, so then the central will prevail. Another section is the overriding effect of IBC, because IBC is a later legislation. And in interpretation of statutes, there is a principle that the later legislation must get precedence over the earlier legislation, because there is an interpretation that whatever is the latest legislation that has been made considering the earlier legislations. So if there is a repugnancy, if there is a contradiction between a central and a state, so then state must give way to the central. Central will override. And if there are two central legislations which are conflicting, then the later legislation will prevail. So because of the overriding effect of this Central Act over the State Act, so this application was admitted against Innovative Industries. Okay. Second was that during CIRP period, the powers of the board stand suspended. But here, the appeal was filed by the erstwhile directors on behalf of the company. Because there is a rule in insolvency that once the insolvency process starts, the powers of the board stand suspended. But in this case, the appeal was filed by the directors. So whether appeal can still be filed? So they said, this is one of the first cases of IBC. So they said, the Supreme Court found substance in the appeal taken on behalf of ICICI Bank that the present appeal at the behest of the erstwhile directors is not maintainable. According to Supreme Court, once an insolvency professional is appointed to manage the company, the erstwhile directors who are no longer in management obviously cannot maintain an appeal on behalf of the company. Okay? In the present case, this being the first case, the present appeal is obviously not maintainable. However, the Supreme Court refused to dismiss the appeal on this aspect because it noted that it was the first application that was moved under the court, and it considered it necessary to deliver a detailed judgment so that all courts and tribunal may take notice of this judgment. Okay, ji? This paradigm shift in the law. So there was discussion on the supremacy. So what they said? Supreme Court said that Maharashtra Act is referable to entry 23, list 3, and code is a parliamentary law. Okay? It is given in list 2. So it says Supreme Court held that for the reasons stated below, the Maharashtra Act cannot stand in the way of this CIRP. Okay? Maharashtra Act is repugnant to the code. As under the Maharashtra Act, the state government has the power to take over the management of the undertaking and impose moratorium in much the same manner as that contained under the code. Okay? So unless Maharashtra Act is out of the way, the parliamentary enactment will be hindered and obstructed in such a manner that it will not be possible to go ahead with the insolvency resolution. So Supreme Court said that the tribunal was correct in appreciating that there would be repugnancy between the provisions of the two enactments. ठीक, तो ये दो हमारी जजमेंट थी. One was on section 7 and another was section 8 or 9 application. So let us take the case of an auditor. You are an auditor of a company. Your dues are, say, 2 crore rupees. The company is not paying. So what are the options available to you? And what you will do in such a case? You are a chartered accountant. You have performed various services for the company. The total amount due is 2 crore rupees. Some of that is billed, some of that is not billed. Now, company is not paying you. So what are the actions you can take? Whether you can file a Section 9 application. So you have to give your answer along with reasons. Yes, please. Situation I have explained to you. You are a chartered accountant. You have rendered services to the company. Total amount due is say 2 crores. Some of which is billed, some of which is not billed. Now, whether you can take action under this IBC. If yes, then what are your arguments? If no, then what are your arguments?
But they have to serve the notice. That they have to keep a copy.
Okay. So in the notice, what they will give? Actually, there could be two
Whatever the
situations.
services they have.
Either there could be a copy of the invoice. If you have already raised the invoice, then you will enclose that copy of the invoice with that. If you have not yet raised the invoice, because you may not be raising invoice on day-to-day basis. Okay? If you are engaged with the company, so you might be rendering services on a continuous basis, but you may not be doing billing on a continuous basis. So then in that case, you will issue a demand notice. Okay? So demand notice or copy of invoice. In demand notice or copy of invoice, what are the points you have to take into consideration? First of all, there has to be a delivery. There has to be a service of the demand notice. That much you will have to prove while filing your application. Suppose the premises of the company are closed, then what? How will you serve the demand notice? Premises of the company are closed. They have fled out of the country. Directors have fled out of the country. So, what you will do in such a scenario?
Through mail, we can send.
Okay. Or you can paste a copy at a conspicuous place if that place
Yes,
is
sir.
available. Or you can email a copy to the directors also.
Yes.
So you have delivered the demand notice or copy of invoice. Service is proper. Whether you have to wait. So for how much period you should wait before taking any further action?
10 days, sir.
10 days from where? 10 days from
Delivery of
delivery or 10 days from dispatch?
delivery of notice.
Right. So 10 days, for 10 days you have to wait. Now, what are the options available with that company? What that company could say? When they receive this demand notice or copy of invoice, what they could say?
Either they can reply with the dispute if they are having existing dispute, or they can send a reply with the payment acknowledgement.
Right. So first thing is they could say that, okay, you are demanding this much money, but there is a deficiency of service. You know, that means a dispute exists. And that whether they can raise this plea for the first time, the answer is no. So they will point out to an earlier communication. We have raised this issue in the past also, that we are not satisfied with your services. You know, so they will raise this issue. So that means they will prove that there was a dispute prior to receipt of demand notice. Because once they have received this demand notice, then that point they cannot raise. So they have to point out to an earlier communication that a dispute exists. Whether a suit or arbitration proceeding is pending or not, it doesn't matter. Or they could say that, okay, they have already made the payment. Now, in case they don't say anything or they don't revert, then what is the option available to you as an operational creditor?
to file an application to
Yes. So then
adjudicating
you can
authority.
file an application.
To
So
adjudicating.
yes. So then you can file the application with the adjudicating authority and closing all the documents. Whether it is necessary for you to give the name of a resolution professional who will act as IRP?
No, sir.
No, it is
No,
not necessary. It is only necessary in case of an application by
By
a financial
operational
creditor or a
or
corporate
operational.
applicant on behalf of the
Okay.
corporate debtor. Okay. So now I think this much we have covered. We have covered up to section 10A and we'll go with section 11 tomorrow.
1 minute. Suppose they have raised the objection stating that we have not satisfied with the service long back. They quoted that mail or something earlier things. In such case also we can proceed with file application.
No, we cannot file the application. We can move ahead with the application, but then before the adjudicating authority, we will have to prove that it was not merely a feeble argument. Basically, then both the parties will argue. Na? Suppose the company reverts back
correct.
that okay, we are not satisfied with your services and we have pointed out this fact in earlier mails also. So now how you can rebut this thing? You can rebut this thing before the adjudicating authority. Then adjudicating authority will decide whether a dispute exists or not. But the chances are there that the adjudicating authority may not go into the merits of the dispute. So if the corporate debtor can prove that this fact was pointed out, there is a deficiency of service and it has been pointed out more than once. So then this you will not be able to file an application under IBC. You have to go through the court route. Because money is due to you. So then you will approach civil court having competent jurisdiction or commercial courts. Because this is for the benefit of the corporates, not for the benefit of the creditors. This mechanism of IBC is not for the benefit of the creditors. It is for the benefit of the corporate persons who are undergoing this process. So they will try to resolve that thing first. And if that is not possible, then liquidation. So thank you so much. So we'll try to cover up to section 30 tomorrow. So we'll hurriedly go through this CIRP procedure and then we'll go section by section in detail along with case studies so that we can cover it up fast. Thank you, Ji. Thank you so much.
Okay, good. Thanks, sir.